The relocation demand gave me 2 weeks to move across the country or resign. My employment contract specified 120 days advance notice and full relocation assistance for any company-initiated transfer. I'd been working as a senior data analyst at a financial services company in Minneapolis for 3 years. My role was office-based. My contract included specific provisions about location changes. The email from my director came on April 3rd. Subject line: Office consolidation, action required. Due to operational restructuring, your role is being relocated to our Phoenix office. You have until April 17th to confirm your relocation or submit your resignation. No relocation package will be provided. My employment contract was dated June 15th, 3 years prior. Section 7.3 stated, in the event the company requires employee to relocate to a different office location, company shall provide a minimum of 120 days advance written notice and a standard relocation package, including moving expenses, temporary housing, and travel costs. The April 3rd email provided 14 days' notice and explicitly stated no relocation assistance would be offered. My name is Ashley. I analysed financial data for corporate clients. I built risk assessment models. I reported findings to executive leadership. I'd worked in the Minneapolis office since I was hired. My contract specified Minneapolis as my primary work location. Now they wanted me in Phoenix in 2 weeks with no assistance, or they wanted me to quit. I opened my contract file and started reviewing the relocation provisions. Section 7.3 was clear. Company-initiated relocations required 120 days written notice. The notice period allowed employees to prepare for the move, find housing, arrange family transitions. The section also specified a standard relocation package, moving expenses covered, temporary housing for up to 60 days, travel costs for house hunting trips, spouse job search assistance if applicable. None of that was mentioned in my director's email. I also reviewed Section 7.4, which addressed what happened if an employee declined a relocation. If employee declines a company-initiated relocation, employee shall be entitled to severance pay equivalent to 1 month of salary for each year of service, with a minimum of 3 months. I had 3 years of service. That meant 3 months of severance if I declined the relocation. The email had given me 2 options: relocate immediately with no assistance, or resign. Resignation meant no severance. Declining a company-initiated relocation meant severance under Section 7.4. The email hadn't mentioned that option. I saved copies of my contract and the April 3rd email to 3 separate locations. Then I responded professionally. I received your email regarding office consolidation. I'm reviewing the relocation terms outlined in Section 7.3 of my employment contract and will respond formally within the contractual timeline. I sent the email at 4:47 p.m. and continued working on my current project analysis. My director replied the next morning. The April 17th deadline stands. Please confirm your decision by then. I noted the response and didn't reply immediately. Instead, I consulted an employment attorney. I scheduled a consultation for the following Tuesday and brought my complete contract and the relocation email. The attorney reviewed both documents for 20 minutes. Your contract is explicit, she said. Section 7.3 requires 120 days notice for company-initiated relocations. They've given you 14 days. Can they override the contract terms? Not unilaterally. This is a binding employment agreement. They'd need your consent to modify these terms, Or they'd need to demonstrate that the relocation doesn't qualify under Section 7.3. What should I do? Respond formally. Reference Section 7.3 and Section 7.4. State that you're willing to discuss relocation under the contractual terms, or, if the company prefers, you'll accept the severance provided in Section 7.4 for declined relocations. Should I send that to my director? Send it to HR with a copy to your director. Make it formal and documented. I drafted the response that evening. Professional, factual, clear. I am in receipt of the April 3rd relocation notice. My employment contract, Section 7.3, specifies that company-initiated relocations require 120 days advance notice and a standard relocation package. The current notice provides 14 days and states no relocation assistance will be offered. I am willing to discuss relocation under the terms specified in my contract. Alternatively, per Section 7.4, I am entitled to severance equivalent to 3 months of salary if I decline the relocation. Please advise how the company would like to proceed. I sent it to HR on April 8th, with a copy to my director and BCC to my personal email. HR responded 2 days later. We are reviewing your contract terms and will respond by April 15th. I noted the date and continued my normal work. The April 17th deadline passed without any response from HR or my director. I documented the missed deadline and waited. On April 18th, my director sent a follow-up email. You were expected to confirm your relocation or resignation by April 17th. Your continued presence in the Minneapolis office is pending resolution. I replied, I responded to the relocation notice on April 8th and am awaiting HR's response per their April 10th communication. No further emails came that week. On April 22nd, I received a meeting invitation from HR, the HR director, my director, and me, scheduled for April 25th. I accepted the meeting and prepared copies of all relevant documentation. The April 25th meeting was held in a conference room on the HR floor. The HR director opened the conversation. We've reviewed your contract and your response to the relocation notice, she said. Your contract does include specific provisions regarding company-initiated relocations. I waited. The company's position is that the office consolidation represents a business necessity that supersedes individual contract terms. Does the company have legal advice supporting that position? I asked. She paused. We believe the restructuring circumstances justify expedited timelines. Section 7.3 doesn't include exceptions for business necessities or restructuring. It specifies 120 days notice and full relocation assistance for any company-initiated transfer. My director spoke for the first time. We're offering you the opportunity to relocate and maintain your position. Many employees would be grateful for that option. I'm willing to relocate under the contractual terms, I said. 120 days notice and the standard relocation package. Or, if the company prefers not to honour those terms, Section 7.4 provides for severance when an employee declines a relocation. Severance is not applicable here, my director said. You have the option to relocate or resign. Resignation and declining a company-initiated relocation are different scenarios under my contract. Resignation provides no severance. Declining a relocation provides 3 months of severance per Section 7.4. The HR director made notes. We'll need to consult with legal counsel, she said. We'll respond within 1 week. The meeting ended. I returned to my desk and documented the conversation. 1 week passed, then 2 weeks. No response from HR. On May 15th, my director sent another email. Your relocation status remains unresolved. Please confirm your intentions regarding the Phoenix position. I replied, I responded to the relocation notice on April 8th. I attended the April 25th HR meeting to discuss contract terms. I am awaiting the company's response per the HR director's commitment to consult legal counsel and respond within 1 week. The next day, I received an email from the company's legal department. Subject line, Employment Contract Review. The email requested a meeting to discuss my contract terms. I was asked to bring my signed contract and any related correspondence. I scheduled the meeting for the following Monday. The legal department meeting included the company's senior counsel and an HR representative. The senior counsel opened with a direct statement. We've reviewed your employment contract and the April 3rd relocation notice, he said. Your contract clearly specifies 120 days notice and relocation assistance for company-initiated transfers. I nodded. The notice provided did not meet those contractual requirements. Correct. The company has 3 options. First, provide you with the contractual 120 days notice from today and the full relocation package. Second, allow you to decline the relocation and provide the severance specified in Section 7.4. Third, terminate your employment, which would trigger wrongful termination provisions under Section 9.2. What does Section 9.2 provide? If the company terminates your employment without cause, you're entitled to 6 months of severance plus continuation of benefits. He copies the contract. The company would like to avoid litigation. We're prepared to offer a settlement that addresses the contractual issues. What would that include? You would be released from the relocation requirement. You would receive 4 months of severance. The company would provide a neutral reference. Both parties would sign a mean release. My contract provides 3 months for declined relocations and 6 months for wrongful termination. 4 months is between those amounts.
Correct. It's a compromise position that acknowledges the contractual issues without full admission of breach. What's the timeline? We can have an agreement drafted within 3 business days. You'd have 1 week to review with your own counsel. I considered the offer. I'd like to consult with my attorney before responding. That's expected. Please let us know by end of week whether you'd like to proceed with settlement discussions. The meeting ended. I contacted my employment attorney that afternoon. She reviewed the proposed settlement terms. 4 months is reasonable given the circumstances, she said. You could push for more, but litigation would take 6 to 12 months with uncertain outcome. This gives you immediate resolution and payment. What should I negotiate? Ask for 5 months. They're already acknowledging the contract violation by offering above the 3-month minimum. See if they'll move to 5. I sent an email to the senior counsel the next day. I'm willing to discuss settlement terms. Given that my contract provides 3 months for declined relocations and 6 months for wrongful termination, and given that the company's relocation notice violated multiple contract provisions, I would accept 5 months of severance plus benefits continuation as outlined in the proposal. The senior counsel responded within 4 hours. The company will agree to 5 months of severance. We'll draft the settlement agreement and send for your review by end of week. The agreement arrived on Friday. I forwarded it to my attorney immediately. She reviewed it over the weekend and called me Monday morning. The agreement is standard and properly drafted, she said. It releases both parties from claims related to the employment relationship and the relocation issue. I'd recommend signing. I signed the settlement agreement on May 29th. The company countersigned on May 31st. The payment was processed within 2 weeks. 5 months of salary. Benefits continuation for 5 months. Neutral reference agreement. I updated my resume and started reaching out to my professional network. Within 3 weeks, I had interviews at 4 different companies, 3 in Minneapolis, 1 remote position. I accepted an offer from one of the Minneapolis companies in July, senior analyst position, 20% higher salary than my previous role, better benefits package. I started the new position in August, 4 months after the original relocation demand. The work was similar: data analysis, risk modelling, client reporting. But the contract was more carefully drafted, clear provisions about location, specific notice requirements for any changes, detailed severance terms. A year after the settlement, I was promoted to lead analyst. I managed a team of 3 junior analysts. I reviewed their contracts and ensured they understood their employment terms. 2 years after leaving my previous company, I was recruited for a director-level position at a larger firm. The role came with significant equity and comprehensive relocation provisions should the company ever need to move my position. I reviewed the contract carefully before signing. Every provision, every clause, every timeline. 3 years after the April relocation email, I was managing analytics operations for a team of 15 people. We developed clear employment protocols, standardized contracts, defined notice periods. No one on my team would receive a 2-week relocation demand that violated their contractual terms. The original employment contract from my previous company was still in my files. Section 7.3 with the 120-day notice requirement. Section 7.4 with the severance provisions. Not as a trophy. As a reminder that employment contracts define obligations for both parties, and when one party violates those terms, the other party has specific remedies. My director had demanded I relocate in 2 weeks or resign. My contract had required 120 days' notice and relocation assistance. The company's legal counsel had reviewed both documents and reached the same conclusion I had. Everything after that had just been settlement negotiation. The 5-month severance I'd received 3 years ago had given me time to find a better position with a stronger contract and higher compensation. That outcome had been determined the moment I'd opened Section 7.3 and read the notice requirements that my director hadn't followed.